I am not gonna let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black role.
Buckle up, guys. Today we're diving into one of the most chaotic courtroom sagas you'll see. It begins with a late-night dash to a hotel near the Ohio border, an FBI phone ping, and an arrest while she's holding a child. What started as a simple reaction to sovereign citizen antics unravels into a tense, unpredictable legal showdown where every word counts. And trust me, things are only going to get wilder from here.
This is 210736FY. This is State of Michigan versus Frank Michaud. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am a beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the arrest of coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, it is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the Sixth Amendment grants me the right to know the nature and the cause of the action. And I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes.
All right, guys, this is where the tension spikes. The prosecutor calmly lists bond violations, but the defendant pushes back hard, denying, deflecting, and demanding a venue change. She interrupts, shifts blame, and accuses others of harassment. The judge tries to steer things back, but every question veers into another rant. You can tell already, this is no ordinary day in court.
Anything else?
Yes.
What's next?
Is this going to be civil or criminal? And I also want to, with the basis of the answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and/or transport and/or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.74012 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter, the court's question back to you, sir, is: are you prepared to proceed with the exam in this matter?
No. You still haven't stated the jurisdiction of the court for the record.
Here's the turning point. After repeated interruptions, the judge calls for a competency evaluation. She insists she's fine, claims she's being targeted, and waives letters from her psychiatrist. But the judge isn't swayed, he wants the state's own experts. Suddenly, the whole case pivots into mental health territory, and you can feel the room shift as the stakes quietly climb.
I have identified this court as the 34th District Court to you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as trustee for the.
This round becomes a test of endurance. She frames the evaluation as punishment for asserting her rights, claiming ADHD and ADA protections. The judge pushes back, explaining it's a safeguard, not a penalty. The exchange turns into a battle of wills, her relentless objections versus the court's authority, and you can practically feel the patience wearing thin on both sides.
Mr. Michaud, you're not under any threat. This is a court. You've appeared this afternoon. This case has been called, and if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the court's, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So,
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you,
okay,
but
so
I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party in interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
It says that possession of a deadly weapon is a commercial crime. So we have to I need to have a better understanding if this is a commercial crime. You said this is a crime and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser. And it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operating under? Is this
Mr. Michaud,
civil or criminal? Because it doesn't make sense to me.
You can say that again.
It doesn't make sense.
Now the accusations pour out. She blames one man for ruining her life, stealing court files, and lying to police. The judge offers to involve the state police, but she refuses, insisting the system is complicit. Every attempt at resolution is rejected, dragging the hearing into a spiral of claims and counterclaims that leave everyone watching both baffled and exhausted.
Mr. Michaud, you're asking a compound question, so I'm going to try to answer it. Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27/7211. All crimes are commercial. So I still need to. I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress of coercion, I appoint Sullivan as my trustee for the record.
Here, custody disputes crash into the hearing. She accuses her ex of hiding the kids, giving false addresses, and gaming the courts. The judge reminds her this isn't the place for custody rulings, but she won't let go. With each argument, the personal stakes spill over the legal boundaries, turning what should be procedure into a bitter war fought on every front.
Court was in receipt of a sealed copy of Mr. Michaud's record, and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions will continue.
We close in on an eviction battle, but the energy hasn't cooled. She challenges leases, rent demands, and harassment claims, accusing even the judge of past orders, which he flatly denies. It's the perfect finale to a saga of defiance, mistrust, and relentless courtroom drama. If you enjoyed this breakdown, don't forget to like the video and subscribe to the channel, and we'll see you in the next one.